So Tim, Halloween's right across the corner. What are you thinking about being this Halloween?
I don't know, man. I'm sort of back and forth, but I think it'd be pretty hilarious to go as a Mexican.
A Mexican?
Yeah, you know, like sombrero, maracas, like, especially with the whole Trump thing right now, it'd just kill at a party.
You do realize I'm Mexican. That's pretty offensive.
I really don't think it's that big of a deal, you know? Like, I'm celebrating it, right?
I wouldn't say celebrating.
Whatever, I'm just gonna go grab a Mexican costume.
All right.
Ugh. What a pain. No wonder all these kids are failing. They can't even get to class. Welcome, students. This is English 15. As you all know, we're going to be talking about grapes of wrath today.
Oh, excuse me, Miss Ketchmeyer. I'm sorry I'm late. I didn't know where I was going.
Oh, that's all right. I know you're on colored people time.
Good evening. I'm Marcus Whitehurst, Vice Provost for Educational Equity. And on behalf of the Office of the President, the Office of Educational Equity, the College of Communications, Dickinson Law, Penn State Law, and the Paul Robeson Cultural Center, I welcome you to our all-in panel discussion on the First Amendment and its intersection with diversity and inclusion. Let's give our student actors a hand for their introduction. At this time, please, for some opening remarks, join me in welcoming Penn State President, Dr. Eric Barron.
Well, thank you for being here. We live in a rather interesting world. I'm not sure, as I get older here, that I've ever seen anything quite like it. At a university, we value speech and discussion and the expression of ideas. Otherwise, we wouldn't be a great university. But at the same time, we've come to live in a world of rather toxic political language and toxic racial language, and you could make a very long list of putting toxic and then the word language at the end of it. Nothing to do with the emerging issues of society, but I had someone come up to me and take my picture, and I said, "You wanted my picture?" And he said, "I need something to scare away the rats in my attic." And I go, whoa. But I think many of you have heard and read much worse. Sometimes it's designed to provoke. Sometimes it's designed to make sure that you get angry. Sometimes it appears just to be based in hate. And I know that it's something that in this society, in the world society, that's very difficult to avoid. I don't understand the reasons, but very difficult to avoid. Well, as a university, we also value diversity, and it's growing. And if we look at our university, whether it's religion or race country, ethnicity, sexual orientation, economics, age, veteran, non-veteran. All of this provides a richness to this university that makes us a rather unique place on this planet. So, we have a problem. How can a university be inclusive and make students and faculty and staff feel welcome in the face of such tremendously toxic language? It's an incredible tension, a tension between a legal obligation, a constitutional right of free speech, that if restricted, you end up with countries that look like dictatorships for which you begin to question who gets to restrict whose speech. And the tension is with a moral obligation to be inclusive and educate the people of our Commonwealth and a nation. So this tension between a legal obligation, a constitutional right, and a moral obligation is rather profound. Universities are ground zero in that debate. There's just simply no way around it. And my impression is we're all doing really poorly in this space. And everybody's treating it a little bit differently and creating rules and policies and a whole litany of do's and don'ts, and spending more time talking about the boundaries, perhaps, than what we might view to balance the notion of this constitutional right and at the same time a moral obligation. This is the part of the reason why this university has focused on a commitment called All In. We play all or we play none is part of our heritage. It's the basis of we are, and part of that we are is to realize that every time you see a single person on this campus, they deserve the right to be here because they earn the right to be here. And there's value in getting to know that individual before we make a judgment. So this is our purpose, and it's one of, rather than the institution contemplating rules and policies and committees, but instead to promote the type of conversation that allows us to at least understand this tension between a constitutional right and a moral obligation. And so I very much appreciate the fact that we have quite a few scholars that are here, and I appreciate you being in the audience, and I look forward to a really interesting evening. Thank you.
Thank you, Dr. Barron. Now I'd like to introduce our panelists. First, we have Carla Pratt. If you can join us on stage. Carla is Associate Dean for Academic Affairs and Educational Equity and a Lamont Faculty Scholar and Professor of Law. Please join me in welcoming Carla Pratt. Next, we have Steve Ross, Professor of Law and Vovacus Distinguished Faculty Scholar. Please join me. Next, we have Victor Romero, Associate Dean of Academic Affairs and Kavanaugh Distinguished Faculty Scholar and Professor of Law. And joining us via Skype from California, we have Robert Richards, a Curley Professor of First Amendment Studies. And finally, and last but not least, our moderator, Steve Dunham, Vice President and General Counsel.
Okay. Good evening. Nice to see everybody. Here's the format we're going to try to follow. I'm going to take just a few minutes to try to frame the issue. Dr. Barron has done most of that already, and I'll just restate some of what he said less eloquently, but try to frame the discussion. Then we'll ask each of our panelists to take 2-3 minutes and comment generally on their views and understanding of First Amendment issues as it relates to issues of diversity and inclusion. And then we'll go to a dialogue, we hope, with members of the audience. Remember, all of us are legally trained. We may call on some of you. And we hope to generate a true conversation. That's a trendy word, but it works in this setting. We're hopeful to get from many of you, particularly the students in the audience, if I may say. This is not an academic panel to talk to law professors. This is a part of a year-long program Dr. Barron and Marcus have led to generate conversation in the community about diversity and inclusion issues. Tonight is a free speech aspect of that, but it remains a community conversation about diversity and inclusion. And we very much hope you all will participate, say what's on your mind, ask questions. We're going to use the skits that were done at the beginning and build on that. Just make up facts, which is what we do in law school. Just make up whatever works for purposes of framing an issue, and probably try to frame some hypotheticals which address the most common First Amendment diversity inclusion issues that arise on campus. And then the panelists in that dialogue section will be answering your questions, responding to your comments, and engaging in back and forth among themselves. So first, just a minute or two to frame the issue. The themes are the ones Dr. Barron mentioned, and I'm going to state them even more simply, to almost harshly, to frame the dialogue. Universities, including Penn State, are committed to freedom of expression. Full stop, full commitment, historical, mission-oriented commitment to freedom of expression. If you're a public university, you are constitutionally required to be committed to freedom of expression, and we are a public university, and we are constitutionally required to protect and embrace freedom of expression. Universities, including Penn State, are committed to principles of diversity and inclusion. It certainly is a moral commitment. Dr. Barron addressed that. But it is, of course, more than that. Dr. Barron has spoken to these broader issues in other contexts. It's a educational imperative. It's a commitment that improves excellence by increasing the pool of people, students, employees, faculty members. Diversity and inclusion is an effort at excellence, in addition to being a moral imperative. And finally, at the level of discrimination, harassment, sexual and racial, diversity and inclusion is also a legal obligation, because we as an institution subject to various federal statutes and the Constitution, Equal Protection Clause, are obligated to not discriminate, to protect gender, race, other groups as a legal matter, in addition to the moral matter, the economic matter, and the academic excellence matter. So we're committed to both, completely without caveats. However, at one extreme, certain speech in certain circumstances is always absolutely protected. The example that most lawyers and law professors would give to you is the Ku Klux Klan marching down the streets of Skokie, Illinois, obviously causing tremendous pain, potential violence, contrary to the constitutional principles of equal protection, and yet clearly 100% protected under the First Amendment. At another extreme, there are numerous examples of speech which are absolutely not protected by the First Amendment. There are multiple categories of speech. The ones lawyers like to talk about most commonly are somebody stands up in a crowded theater and cries fire. That causes a panic. People are trampled. That's not protected by free speech. Sexual harassment, racial harassment that meets legal definitions is not protected by free speech. Child pornography is not protected by free speech. There are numerous other examples. Death threats, defamation are not protected by freedom of speech. So we have two extremes here. We have absolute protection of speech in some circumstances, in some settings, and we have absolute protection of other values, safety, non-discrimination, health and welfare, which are protected at the other extreme. And the challenge, and what we hope by hypos and using the skits and hopefully questions from all of you and dialogue, is to start drawing the lines between those two extremes. But not so much, or not only as a legal matter. So we hope to shed some light on the legal principles, and the panel will be addressing things like what is the First Amendment, what are the exceptions, how does it apply on a university campus, what are the situations. And the law does speak to that, and we're not going to run away from the law, so we'll try to address some of those. But at the same time, as Dr. Barron mentioned, a lot of these principles are what I think Bruce Springsteen would describe as in the shadow of the law, right, on the edge of the city. They're part of, but not required by, the Constitution or by legal rules. And so we can draw from the law, and we can draw from society's standards of morality and society's standards of doing the right thing and society's standards of developing a culture of civility and respect. We can draw from those principles, policies, ways to do business, which are not dictated by the law, but which are good things to do and which our university would like to do. And so we're going to hopefully address both of those. Both when does the law tell us what to do and what we can and can't do, and when does our sense of justice or conscience tell us, or just good business tell us how we should operate. Okay, so framed that way, there's a lot of just information to get out there, but we're not going to drone on because we really do want you to speak. So I'm now going to turn to the panel and ask each of them, we can start with Carla because she's closest, and just move down the line, to take 2-3 minutes and share her views on this subject with you, and then after they finish that, we'll open it up for questions and comments. Carla.
So I agree with what's been said. I want to thank the organizers of this panel, particularly Marcus Whitehurst, who invited me to participate and I think conceptualize this with President Barron and recognize the need to have this discussion. I think it's really important to set this as part of the agenda for discussion at Penn State, and I'm glad to be a part of it. So President Barron mentioned that there's a tension between the First Amendment constitutional obligation and the moral obligation of diversity and inclusion, and I definitely agree with that. And I would add that there's also an internal tension within the Constitution itself, and that internal tension is between the First Amendment and the 14th Amendment. So the First Amendment, which of course grants free speech rights, and the 14th Amendment's Equal Protection Clause guarantee, which guarantees that we're all going to be treated equally under the law. And so that internal tension arises because you'll recall the original Constitution did not contain any amendments, right? And so when the original Constitution was adopted, it was adopted in a way that envisioned that we would be a society very different from the society that we ultimately became. So the original Constitution envisioned the body politic of the democracy being white, with Indians being, Native Americans being a different class of people, not really envisioned in the body politic, and African Americans being property and also not really envisioned as part of the body politic. And so we get the Reconstruction Amendments being added to the Constitution after the Civil War in an attempt to correct that original defect of the document. And the 14th Amendment gets added as an opportunity, one, to make the newly freed slaves citizens, and two, to elevate them to a position of equality, a position of political equality, but that many would argue that whites already enjoyed from the original Constitution. So if you view the 14th Amendment, as I do, as being a tool that was added to the Constitution to correct for an original defect, and you interpret it as we do in law, we say if a provision of a law is added later, it has to modify everything that came before it, because the people who added the later provision understood that the original provision existed, right? And so the 14th Amendment then, coming after the First Amendment, must necessarily modify the First Amendment and curtail it so that, to the extent that there are 14th Amendments that need to be upheld, the First Amendment has to yield. So the First Amendment is not absolute, despite the fact that many of us want to think about the First Amendment in absolutist terms because we're so committed to free speech. As Steve pointed out, it's not absolute. You can't scream fire in a crowded theater, and you can't engage in speech that defames or threatens or intimidates. That's not protected by law. So we have this internal conflict that creates this difficulty, and I think the Supreme Court has been more inclined to privilege First Amendment interests over 14th Amendment interests, and that's one of the things that I've written about as a scholar in terms of challenging the court to be more cognizant of respecting 14th Amendment rights and interpreting the First Amendment in light of the 14th Amendment's equal protection mandate.
Okay, thank you. Steve, why don't you go ahead?
Thank you for having me. I was asked to be here because I do comparative constitutional law with the principal focus on Canada and a passing knowledge of South Africa. They have more recent constitutions, so they don't have to do deal with the interpretive issues that Dean Pratt just mentioned. The South African Bill of Rights has a specific provision, Section 10, that says everyone has inherent dignity and the right to have their dignity respected and protected. They have a free expression provision as well, which is in Section 1, which guarantees various forms of free expression of 16 Section 1. And then they have a specific text that says, the right in subsection 1 does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. The Canadian Charter of Rights and Freedoms has a right to the freedom of thought, belief, opinion, and expression in the Constitution. They also have an equal protection clause like ours, and significantly, they have Section 27. This charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians. From this background, all of us wrestle with the question Dr. Barron posed: how to be inclusive in the face of toxic language. What these countries show is that the choice is not tolerance of toxic language or totalitarian dictatorships. Canada seems to be functioning fine, despite the fact that the clearest case that Steve Dunham mentioned would almost certainly be illegal and criminal in Canada. Finding those boundaries is a task that has to be understood within the context of a specific country. It's a lot easier to do it in South Africa, which had apartheid, and so when you talk about human dignity, people know what you're talking about in that context. Canada, in some ways, is more similar to us, and the question is, can we chart a path drawing on some of these examples, or is there something about the American Constitution and the American value system that doesn't allow us to chart that path? My contribution is to point out that the way we do things here isn't necessarily the way we always have to do things. And the reality is that some of the more pro-free speech decisions of the US Supreme Court are 5-4 decisions. And so part of that conversation I think we need to have here is, as a state university, we have to follow the First Amendment as it is interpreted by the courts right now, but we also ought not to lose sight of what is the right thing to do, what is the right balance. And it's really not, in a government of laws, it's not terrible to say what we want to do is right, we can't do, but let's see how much we can do that still is right within the limits of the law.
Okay, it may be addressed in the next two, but one thing we want to specifically come back to is Steve's quote from, I think it was the South African Constitution, about advocacy of hatred, because that is what on college campuses is probably the most common tension between free speech, with people saying you're allowed to say whatever the heck you want, and groups and individuals who feel threatened and unsafe and unwelcome because some other person or some other group is advocating hatred. So let's keep that concept in mind when we come back to hypos, but Carlos, why don't you go next, and then we'll come to Bob at the end.
Okay. Thank you, Steve. Thank you, everyone.
Victor, excuse me, sorry.
No, that's all right. I'll respond to Carlos. So like Dean Pratt and other scholars, I think of Mari Matsuda, Richard Delgado, I also believe that the First Amendment cannot be read outside the 14th Amendment's commitment to equality and due process. So that means that the court's commitment to equality provides a gloss over our free speech rights, such that free speech rights are not absolute and should take into consideration the realities of inequality in America and the legacy of slavery, gender equality, inequality, etc. But here's the rub. Sometimes there's a temptation to add new laws to protect subordinated groups, such as hate crime laws, for example. But what happens in reality is that they're actually enforced against these vulnerable minorities. In fact, when the US Supreme Court upheld penalty enhancements as part of a hate crime legislation, it did so in the context of a case in which African American defendants were being tried for beating up a white person, not the other way around. As such, I think that in a public university context, more speech may often be a better solution than more law, and that the First Amendment can be used as a tool to advance equality and inclusion. Let me give you an example. Steve talked about the idea of hypotheticals, so here's your first one. A student tells a faculty member that she is going to attend a Ku Klux Klan rally. So one law-based solution might be for the faculty member to not excuse the absence, declaring that such attendance is inconsistent with the values of diversity and inclusion that the faculty member is trying to inculcate. A First Amendment solution or alternative might be to take the opportunity to talk to that student about why she plans to attend the rally and try to understand and initiate a conversation that would hopefully provide a teachable moment. In my experience as a teacher, more speech leads to more understanding, even around difficult subjects, as long as we can commit to civil, even if impassioned, discourse. Thanks.
Okay, now we're going to see how our high tech works. So, Bob, I think we're pushing a button and making you live. So you're on.
Great. I hope you can hear me. I've had a little fear in you folks, so I'm going to play the role tonight of a presidential candidate. I'm going to pretend I heard the question, but I'm going to answer the question I wish you asked. In preparing for tonight's event, I was thinking about Justice William Brennan. And Justice Brennan is a hero of mine on the Supreme Court. He died in the mid-1990s, but I had in the last part of his life the great opportunity to get to know him a little bit, because I wrote a book about him and his legacy to the First Amendment. And one of the opinions that he wrote in the case called Texas versus Johnson back in 1989. It had a line in it that I will never forget. I quoted it many times, I've quoted it in my books, my articles, and it's this. And I think it kind of, for me, encapsulates what the First Amendment's all about. He said, if there's a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds that idea itself offensive or disagreeable. And so a really simple line, but for me, as for the last 25 years that I've run the Center for the First Amendment at Penn State, been one of my guiding principles. We don't need a constitution, we don't need a First Amendment to protect the rights that everybody likes, or the views rather that everybody likes, the viewpoints, the ideas that everybody likes. The majority takes care of itself. You need a First Amendment to protect the minority viewpoint, the unpopular viewpoint, the viewpoints that people despise, the viewpoints that people would much rather have eradicated from our public discourse. Now I'll give you some examples from just the last couple of years and cases that my center and myself have filed briefs in, what are called amicus curiae, or a friend of the court briefs in the United States Supreme Court. One of the cases involves the Westboro Baptist Church. Now, if I were to do a survey of all Americans, probably 99.99% of the American public would hate the Westboro Baptist Church. And I can tell you, I personally hate the views of the Westboro Baptist Church. But I did file a brief on their behalf, and I went even further. Myself and a number of people who run First Amendment centers around the country went to the University of Virginia 3 weeks before the Supreme Court argument and helped train their lawyer, who was also a member of that church because she was the daughter of the founder, to prepare that argument before the United States Supreme Court. I got a lot of email for that. I got somebody, it was written up in USA Today, and somebody wrote the former president of Penn State and said I should be fired for what I said, or what I did in filing a brief in that regard. But when the case came down, it was an 8-1 decision in favor of the Westboro Baptist Church. Not that any of those 8 justices on the Supreme Court liked what they had to say. Rather, they knew that we had to protect the right for them to say it. And that is what the First Amendment is all about. Again, you don't need a constitution to protect viewpoints that people like. The majority can take care of itself just fine. But clearly, a majority, a vast majority, if not almost the entire country, would despise the types of things that the Westboro Baptist Church had to say. And I do myself, personally. But as a lawyer and as a First Amendment advocate, I have to defend the right to say it. So as we go through this session tonight, I would like everybody to kind of remember that point, because it's very easy to kind of, get into a groupthink where we say, oh, there's things we don't like, I don't want to hear that kind of stuff, and no, neither do I don't want to hear it either. But I'm going to defend in court everybody's right to say that. And I did it with Anthony Alanis, who was a case in the Supreme Court about a year or 2 ago, where Alanis wrote some very threatening, awful rap lyrics, or he claimed they were rap lyrics. He's not even a rapper. But he claimed they were rap lyrics on his Facebook page against his ex-wife, against some law enforcement, and so forth. And we filed a brief in that case. So a lot of times people look at the kind of work that I do and say, how on earth can you get up in the morning and face yourself in the mirror knowing that these are the type of people you represent? And I said, that's what the First Amendment is all about. We cannot allow government, we cannot allow the majority to censor speech just because, as Justice Brennan so aptly said, that the vast majority of society finds the idea itself offensive or disagreeable.
Okay. Steve, you want to add something?
Yeah, I just want to offer a comparative perspective there. I'm quite sure that Chief Justice Brian Dixon of the Supreme Court of Canada, who was a big admirer of Justice Brennan, would respectfully disagree there in the Canadian context. Canada has, as I read to you, a commitment to multiculturalism. So the idea that Canada should not be a multicultural state and people of different backgrounds should not be welcomed in Canada is an idea that Canadians in their constitution have said they don't really want. They would like to eradicate. It's not just unpopular, like the US winning a hockey game, it's something they really want to eradicate. The South African Bill of Rights has a specific provision that says everyone has inherent dignity, and they had lived through decades of subhuman indignity, and the idea that humans should have to live in indignity is an idea they want to eradicate. Now, the challenge, which makes this difficult, is the original South African Constitution was being enforced by a court of 13 people who were a new court, all appointed by Nelson Mandela. The Supreme Court of Canada has a huge tradition of non-political, well-accepted judgment. Without commenting on the presidential election, other than to say, I've become familiar with these two candidates, neither of them are Nelson Mandela. And one of the challenges is the question that Dr. Barron posed in his initial remarks. Somebody's got to make this decision. And so one of the questions is not just the principle that Bob has advocated, but who's going to do it, and do you want to trust our federal system to make the sort of choices that Canadians trust their judiciary to do, and the South Africans trust their heirs and of appointees of Nelson Mandela to do? Do you want to trust 5 justices on our Supreme Court to make those decisions? And that's some of the difficult questions that we have to face.
Okay, so I think you've heard both what might be viewed as traditionally a more absolutist view, and at least with respect to foreign references, what is more comparative, value-laden view, which a couple of the other professors would also support by citing the 14th Amendment, for example, as building into our system an ability to recognize, at least in the case of race, that there are competing values. But I want to bring it down now to students, and in particular students at Penn State. And I'm going to open it up for anybody, but let me just frame one of the incidents that gave rise to this program. So at the time of the Black Lives Matter demonstrations, first at Penn State, after some demonstrations went on, there was some vile, racist emails or other social media directed at certain of the black students. And the question came up, well, university, can you do something about that? This is painful, it's harmful, it's threatening. Can you do something about that? So come back to this phrase about hate speech, right? This would meet a definition of hate speech. It would be directed at either a group or an individual. It wouldn't yet be the state, right? It's one student with another student, and the First Amendment requires the government in some way to have a role. So the question is, and I'd like to invite particularly students, but anyone else, to say what you think about should a university, forget Penn State, should a public university have the legal power and authority to discipline students who send hate speech to other students in circumstances that give them legitimate, reasonable cause for fear for issues of safety, as well as just being personally, repulsive and making them feel unwelcome in the Penn State community. So do I have any offers to pick that up? And let me say one other background thing. We hear, those of us in my generation, that if you're under 30, you have less of an interest in and support of First Amendment values, and more of an interest in and support of issues of safety, non-discrimination, welcoming, civility, respect, personal relationships. You balance it as a group. Obviously, that wild stereotype may not apply to anybody in this room, but that's what the studies tell us. Under 30 students vote much less for an absolutist view of the free speech and much more for issues of safety, issues of non-discrimination, issues of welcomeness. Institutions like the university should be able to protect us when we are subject to this kind of speech. So if there's anybody out there who's in that generation who thinks we should be able to protect you, please speak up. We want to generate a conversation on that subject. Yes, sir. in the
Wait,
back.
they have to have a microphone.
Right.
It's being live
Go
streamed.
back with the microphone. There's one in the far back. Okay, here, that's good. Go ahead.
All right, should I stand?
You got the
Stand,
floor.
sit down. Thank you to the panel. A lot of interesting things going in, and coming into this.
Can you speak a little closer into the mic?
Yes, coming into this presentation on free speech, there's certainly a lot of things that I've been doing on campus, and a lot of concerns that I've had with campus in regards to First Amendment protection of the students. I would say I'm in that category where you definitely have to consider where students feel safe, and it's not just an idea of saying where there's a discrepancy between some people say a university being a safe space is everyone being called a special snowflake, whereas when we talk about safe space, it's we're here for an education. We want to go from one class to another without feeling threatened. We want to exist in the public sphere without feeling in danger. And there's definitely conflicts with the university, like on university, where I think this pops up a lot with students, with people who come onto campus, and it's definitely something we're seeing where there's a lot of conflict over it. And I think it's very important for Penn State to make sure that those protections can be in place for those students, because, like, say the Westboro Baptist Church comes onto Penn State's campus, I would be here for an education, but being forced to walk by an entire group of the Westboro Baptist Church and knowing that the university is going to do nothing at all about that would be very disheartening. It would make me feel unsafe on campus. It would make me just feel unsafe at Penn State in general, and just beyond, just kind of a fear for safety, fear for life, fear for if I come onto campus, will there be violence?
Okay, thank you. How about we do the one in the back, and then we'll come back and ask the panel to comment on this issue of safe spaces and how you balance these issues out. Go ahead, sir.
Hi, yes, so my name's Chris Baker, and this actually hits very close to home because earlier in this year, I'm a part of the Trump support group here on campus, and we've had a lot of instances relating to free speech and hate speech. My personal problem with the idea of safe spaces, or with an institution such as Penn State attempting to constrict speech and placing limitations on speech under the guise of free speech, is that when you start to tread into that realm of hate speech, it's very hard to draw the line. It's very hard to understand what is hate speech. Obscenity used to be defined as, you know when you see it, but that got overturned by the Supreme Court. There's no way to know it when you see it. There are instances throughout history of people who were attempted to be silenced, the most notable which is Galileo, when the Catholic Church tried to suppress his free speech when he was talking about, instead of the universe revolving around the earth was in the universe. What happens when you tread into hate speech or limiting speech is you risk silencing someone who has an idea different to the norm, which can open people's minds, change their opinions, change their beliefs, and produce new information that can benefit the whole of society. I'm not saying that there is speech that there certainly is hate speech. There certainly is hate speech that we wouldn't want to be promoted, but you can't start venturing into silencing hate speech, because you really do verge on silencing people who don't deserve to be silenced, and possibly shutting down revolutionary ideas that could help our society moving forward. The Enlightenment was thought of as an era of dangerous thinkers. So when you start silencing dangerous thinkers, that, in my opinion, is the most dangerous aspect of free speech. Free speech is the whole of America is a marketplace of ideas. If someone says something you don't agree with, you don't have to subscribe to that idea. You can turn away and you can subscribe to other ideas, but you can't shut other people down just because you don't like what they're saying or how they say it. That to me is a terrifying truly terrifying realization, and I feel we are moving closer towards that. If you look at what's happened at Yale and some of the Ivy League schools where they do have these safe speeches and they are shutting down free speech, I would like to see Penn State carry the mantle as a champion of free speech moving forward.
Okay, thank you. So those are two really helpful comments that do help frame the issue. I appreciate that. I hope we can have more of that later as we move on to other issues. But let's take the issue of hate speech and safe spaces, just to use code words here, although they're both incredibly complicated and can play out in all kinds of different settings, and ask each of our panelists to comment on whatever you want to say about that general issue of hate speech and safe spaces and how one might balance those issues out. Carla, why don't we start with you?
Okay, I'm not really sure how creating safe space for students on college campuses infringes anyone's free speech. I don't see that it does. I would say that, when I started teaching at Penn State, I remember that was in the year 2000. The KKK marched in Carlisle, Pennsylvania, so you don't have to go to...
Can you all hear in the back?
You can't.
Maybe speak up a little.
Let me just take it off the shirt and use it that way. I remember when I joined Penn State in 2000, the KKK marched in Carlisle, Pennsylvania, so you don't have to go to Skokie, Illinois. They were right here in Carlisle. And I remember Professor Romero started an NAACP chapter in response, because he said, we're not going to be silent in the face of this hate speech. And so I think he's right. I think more speech is the answer. And if the Westboro Baptist Church comes to campus, then we will plan a counter rally that's larger and greater than the speech that they can muster on this campus.
Let me just pause with that and think, and have you all think about what Carla just said, which is if you will, an extra legal remedy or solution. So we don't have to rely on discipline or regulation or closing somebody down. We can exercise our own responsive rights of free speech. And don't forget, institutions, such as Penn State, have their own rights of free speech. So there is an ability consistent with the First Amendment to jawbone, to argue, to be louder, to counter-demonstrate, to counter-march, which can be an effective way without infringing traditional notions of free speech, although some would argue we have more flexibility in infringing traditional notions of free speech than that, but there are these extrajudicial ways that we should keep in mind. So let me jump over, Steve, I'll come back to you, but ask you, Victor, to comment on that.
Well, I think Dean Pratt's given me more credit. I don't know that I ever found it, although I appreciate the
That's the way I remember it.
I appreciate the sentiment. I will say, though, that experience was certainly eye-opening for me. I wanted to go back, though, Steve, to your particular hypothetical, which was the use of targeted speech via email. And so I would draw a distinction between offensive speech, the kind of speech that is in the minority in terms of perspective. So pick your issue, right? Whether it's sexual harassment, affirmative action, whatever hot button issue you want to talk about, and an opinion that you disagree with that was sent by an email. I would distinguish that from a specifically targeted email directed at a specific individual, threatening them with death and that sort of thing. I think that there would be concern about that. Certainly in the tort law, which has to do with personal injury, there is a claim known as intentional infliction of emotional distress. So even within the law, there is a recognition of differences in the ways that things affect individuals, especially if intentionally done. So I'll just stop there since we've...
That's good. So Bob, and then we'll come to Steve. We're going to call you our closet absolutist here, but what comments do you have on the notion of hate speech and what an appropriate response to it is by an institution?
I spoke for 3 minutes in the middle of absolutist. That's great. Let me talk a little bit about what you said in your question, Steve. You talked a little bit about the difference between hate speech and threatening speech. Those are two different things. And as Steve, I think in his opening remarks, from what I could hear of them, I think eloquently pointed out that other countries have a different view on speech than we do. And there are countries around the world that recognize hate speech as a category of speech that can be sanctioned, that can have some penalties that are associated with it. Germany and other countries that do that. And I'm by no means an expert on the world. I will defer to Steve on all that. But in this country, we do not recognize hate speech as a category of speech that is somehow can be punished. The other word that you used was threats. Now, that's a different world. When you talk about threats, true threats, and if it is indeed a true threat under the definition in the law of that concept, then it is outside of the scope of the First Amendment. And so if somebody did get an email that contained a threat to them that could be recognized as a true threat, then they should, by all means, notify the authorities and turn that information over to them. And that is not an issue that rubs up against the First Amendment or somehow is in conflict with the First Amendment, because true threats have been taken out of the First Amendment as a category of protected speech.
Okay. Steve.
Well, I won't call on students here, but I want to follow up on the first student's remarks to create sort of three categories. There's the threatening email that causes, to use Steve Dunham's word, a reasonable apprehension of harm, and Bob Richards talked about that. There's walking past a bunch of Westboro Church protesters going from case A to case B, and a perception that you don't feel safe. And if the reason you don't feel safe is because of an objectively reasonable apprehension of harm, because of something they're saying or doing, then you're in the first category. But I'd like to have more of a dialogue with people in the audience about what exactly it means that you don't feel safe if you're not talking about a specific threat that causes a apprehension of harm. And then there's the third person comment, the other student's comment about safe spaces. And I want to distinguish between somebody who wants to protest, and we haven't gotten into the technicalities of reasonable time, place, and manner, but somebody wants to protest, but there's a place where some people want to go, and they just want an area where they want to be safe from that sort of discussion. They don't feel like having that discussion. And if what a safe space means is a carved out area where we're not going to have that kind of activity, and anybody wants to protest can go protest somewhere else. You want to protest at Old Main, that's fine, but in the LGBT office in Pasquarella Hall is not the place for the Westboro Baptist Church, then that's the third thing. So I think there are these categories we have to talk about here on where you can go.
So let me just say one thing about that that's a really helpful doctrine, and then move to one of the hypos demonstrated by the skits. We may well come back to the hate speech situation because it permeates a lot of this. But so what Steve just said is it depends kind of where you are on campus. And so that is a constitutional law First Amendment doctrine of public forum. In a space which is labeled a public forum, essentially anything goes. At Penn State, as it happens, the way we describe it in the general counsel's office is the whole damn place is a public forum. I mean, everything that's outside is a public forum. We have not designated special places, which is where you can go if you want to spew hate speech. We have said the whole place is a public forum. If you wanted to create safe speech areas, you clearly can do that, as Steve suggested, in the sense of saying these parts of the campus are not public. You know, everything inside, absolutely everything inside at Penn State is not a public forum, so we can control that. Outside, we can't, but you could, and many, many, many campuses do, say the left southeast quadrant of the campus is where you go if you want to have a demonstration. But you can't have a demonstration anywhere else. And you can enforce that. That free speech doesn't require you to do that because you've designated a partial public forum. So that's one way to create a safe space, because then you can be somewhere else and be sure that the Westboro Baptist Church isn't going to come demonstrate, or they could be stopped because it's not a public forum and they wouldn't be allowed to be there. So it's kind of a practical way to address it. So I want to go to the last hypo in the skit, because it moves the speech from student-on-student speech, which is what our previous hypos were talking about, where it's hard to apply the First Amendment to that because it's one private citizen to another private citizen, not in a university context. But move to the end part of it, where the student was a faculty member and says a racially derogatory comment to a student. So what do you think about that? Shouldn't that be subject to more ability of the institution to regulate because it's in the classroom? I mean, everybody would instinctively say yes, but it would be helpful if we have students who want to speak out, obviously on your own circumstances, that's fine, or just hypothetically, are there situations where you are concerned about what faculty members say, don't give us names, but you're concerned about what faculty members say in the classroom or in their offices that cause you to be uncomfortable? Does that happen? Anybody want to speak to that? So there, okay. Yes.
So, hello, my name is Dwayne Wright, and I can speak on it because everyone up there taught me, except maybe for Bob Richards. But I'm going to go back a little bit and kind of frame because I think what we're talking about is very legal, and I appreciate it, and I appreciate the education I got at Penn State, but I think sometimes it can go over the audience heads. So I kind of want to just reframe the conversation. So we're talking really about responsibility here, and what's the responsibility of the university to act. And sometimes what you do is not necessarily always what you do. And I think the imprint from a lot of students of color here at Penn State is that Penn State hides behind the First Amendment sometimes. And we understand your responsibility as a school to acknowledge the First Amendment, but we want you to also understand your responsibility to acknowledge us as students that deserve to be here, that fought hard to be here, because there's not a lot of us here. So I think that when we're talking about whether it be the Westboro Baptist Church or the Students for Trump, what the university does is not always what the university does. So we understand you can't, at least I understand, you can't do things against the First Amendment, but I point out the Oklahoma incident. Everyone remembers the SIA incident and what President Barron did there. And my dean is going to hate that I say this, but I actually liked what he did there, because that response was to say, I stand with my students, and I stand for right and wrong. And sometimes, regardless of what the First Amendment says, there's right and wrong. And we will stand as we are, Penn State, for right and wrong. Before we even stand for the First Amendment, we stand for right and wrong. That might not be the uber legal thing to say, as all my professors are standing there looking at me crazy, but to me, it's the right thing to say. And it's the conversation we should be having today. Because as a student of color, I am fine with people in the Westboro Baptist Church protesting, but at the end of the day, I also need my university to stand up and acknowledge my right to be here, my right to matter, my right to live. So I appreciate the legal conversation, and for everyone that wants to go to law school, Penn State's a great law school, please join us. But I think sometimes it does go over our heads. Now, to the one comment about what goes on in the classroom, I definitely think the university has much more of a responsibility to handle what goes on, because that's affecting my education. I think, as someone that aspires to be a faculty member, as someone that academic freedom is a potent part of teaching. And to the young man's point, yeah, there are always views that are unacceptable. They might be just academic views or just political views that are just unacceptable. But at the same point in time, to actually live and learn in the classroom, certain views must be just held out. And they're not just views that are liberal, whether in the context of political liberal or philosophically liberal. I think that sometimes we as students of color need to compromise. and know that certain views that we bring in the classroom might be extreme and offensive to other students. But the key word there is compromise and responsibility. So I think the university has to acknowledge its super like First Amendment responsibility, knowing that you have a responsibility to help on an individual level, a classroom level, acknowledge the individual dignity of every student in the classroom. And if my teacher is saying something, or if the university is not responding to certain acts in such a way that doesn't acknowledge my dignity, it's wrong. It has nothing to do with the First Amendment, has nothing to do with this great legal conversation we're having. There is right or wrong. And I think before we get to this context, we need to have a conversation and acknowledge that there just is right or wrong.
So that's a terrific comment. Thank you. It's what we were hoping to invite and generate by this conversation of going beyond the First Amendment, going beyond the law and asking, in Dr. Barron's terms, about moral ethics, doing the right thing, and how and what the tools may be that the university has. And that's, back to, one of the tools is Carla's point about organizing counter demonstrations and being louder. And there may be other tools that the university can do in terms of, for example, jawboning with students and saying, you sent this racist email, and it's just wrong. It makes people feel not welcome, all the things you identified. And what I'd like our panel maybe to address, or someone else out there, is what do you think about that? Do you think the university should, as a matter of doing the right thing, weigh in beyond the First Amendment when there is conduct, racial, sexist, various other improper conduct that we can all accept as improper, even when we don't have a First Amendment right to close it down and kick somebody out of school, but we have other things we can do. And that's a really helpful conversation, a really helpful question to ask that. What other things could the university be doing short of disciplinary action or termination proceedings or formal, which does butt into the First Amendment? What are things short of that? And maybe we could have the faculty talk about that. Yeah, Carla.
So I just had an opportunity for this because Halloween's coming. And we know we've had challenges with cultural appropriation and other disrespectful behavior at Halloween with people dressing up. And so what I did was meet with our Dean of Students and enlicit her help to draft a one-page text which could be incorporated into an email. And we shared it with the president of the Student Bar Association and said, hey, we know you guys are getting ready to have your Halloween party. You might want to remind the students that their professional identities are being formed now and that they might want to be mindful of that as they prepare their costume for the Halloween party. And oh, by the way, we just drafted a little text you could use. You can plagiarize this if you'd like to use it to send out to your membership. It's not that we're mandating that they send this. It's that we're facilitating that kind of leadership by students. I think when that message comes from students, it's heard by students differently also than when if it was to come from me. And so having a partnership with student leaders so that student leaders can exhibit the kind of diversity leadership on campus that we want to see, I think is really important.
Okay, any other comments here? Yeah, Steve.
There was a real problem at Columbia about 15 or 20 years ago. An old white male criminal law professor gave a final exam with an incredibly graphic, gratuitous example of rape. Students demanded he be fired. He's a highly chaired professor. The dean, very respected lawyer himself, but I exam. It's offensive. It offends our ideals. It's beneath Columbia Law School. It's really, really bad. The professor fired back a memo saying, oh, the dean is chilling my First Amendment rights and my academic freedom and how I select an exam. And then there was a fortunately successful pushback. No, academic freedom does not mean that you can say whatever you want without consequence. It means you can say whatever you want without getting fired. And I was just talking to Vice President Sharkey about this beforehand. If somebody came up to him, he's the Vice President for Research, everybody, and somebody said, you know, Vice President, I've got this big research project, but I'm really worried that somebody's going to criticize me because I'm using a new technique, and I don't want to take the criticism, so I'm not going to do the research unless we can agree that nobody, at least at Penn State, will criticize my scholarship. He'd look at you like you were crazy. And so I think a lot of times we forget about that, and I think that I don't know exactly what Dwayne had in mind. Great remarks. Proud of you as a Penn State law grad. But I think that there is grounds for both faculty and administration to exercise their own First Amendment rights. And if it chills somebody in the sense that they can't take the heat, well, then that's too bad. That is what the marketplace of ideas is all about.
Victor, do you want to add something to that?
So it's interesting to hear this from my friend Dwayne, because I know, based on many, many conversations with him, that he believes that people should be able to speak their mind, right? To express their opinion, which is consistent with the First Amendment. And I think he also thinks that it's important to make sure that diverse groups express their opinions. But he also said something interesting when he said, but sometimes we should stand up for things that are wrong. And I completely agree with that. And I think what we're hearing, I think affirmed, is this idea that if you see something is wrong, where an individual is being targeted, where a person is subject to hateful action, then it is incumbent upon certainly us as faculty to address that. And if we misstep, it is incumbent upon you to let us know so that, again, more speech, conversations can be had about that kind of behavior along the lines that Steve Ross just talked about. So I don't think anything that my friend said is inconsistent with what I think we've talked about before.
So let me ask Bob, and you can either answer this or say whatever else you want about that subject, but one of the...
I agree very much with Victor and what he has to say, and I was thinking as I was hearing the speaker ask the question about the work that I've done, not at university levels, but as you go one step below the secondary education level, there's a lot of free speech issues that crop up in public schools around the country, and I've spent a lot of time dealing with that issue and tracking those types of cases. But in speaking with, going to conferences or education conferences and speaking to teachers and principals, the one thing I have learned is that this notion of actually stepping forward and doing sort of the right thing, I think as the questioner said, works really well in these situations. And let me give you an example. Too often in the public school system in this country, what happens is that a kid wears a Confederate flag t-shirt to school, and the principal calls him into the office, tells him he's got to turn it inside out or take it off or go home or whatever. And the next thing you know, you're in federal court, literally in federal court, fighting a First Amendment lawsuit. And I've talked to more and more principals who said, you know what I do? I call the kid into my office and I said, you know what? That t-shirt offends so-and-so and so-and-so. And maybe you ought not wear that t-shirt. And as those principals have told me, that works so much better because the kid will say, yeah, I guess you're right. Yeah, I guess I was a fool for doing that. And we'll change his or her ways. But the worst thing that can happen is that knee-jerk reaction where the principal decides to come down and push down the hammer and go after the kid and suspend them and take them out of the football team and all the rest of that stuff. Because all you're going to do is end up in federal court. And in most instances, not all, in most instances, you're going to find that the students are going to win those cases in federal court. Because by the time they win it, they're going to be a senior in college.
Let me make... Oh, there's a comment back there. Go ahead.
So I'd like to bring up an issue that happened a few years ago here at Penn State with the Chi Omega sorority. And for their Halloween costume, a bunch of, apparently who were their pledges, were dressed up in ponchos and sombreros with signs that said, will mow lawn for weed and beer, and I don't cut grass, I smoke it. And while the Chi Omega national headquarters did shut them down, it was Penn State administration that actually said that it was within their First Amendment rights. And as someone in Greek life, I just wanted to ask the opinions of the members of the panel about whether Penn State has either a responsibility or an obligation to kind of intervene in Greek life, especially since that's more of a private organization, and whether or not that the university has a responsibility to intervene, like I said, with situations within Greek life.
Just to be sure, I understood this is inappropriate conduct in the context of a fraternity. Is that a sorority? Okay. So that actually was the next point I was going to raise, and then maybe we can ask about that. That I hope this isn't too much law. I think it merges the law and the do the right thing concepts. When you move away from student-on-student conduct to the classroom, your answer's clearly right about that. Clearly, that has nothing to do with free speech. That's inappropriate. University can come down on people who make those kind of comments in the classroom or in the workplace. Much harder in private student with private student. But where they kind of they come together, to take the University of Oklahoma case, that was a fraternity, right? That was a recognized student organization. And your question had to do with a sorority. That's a recognized student organization. In those contexts, they have more of a tie to the institution. They are more public. They are more part of the institution. And I would argue, but let's find out what the experts think, that it gives the university, both as a matter of legal doctrine and as a matter of doing the right thing, more authority to regulate and restrict racist, sexist, inappropriate conduct by recognized student organizations than we might otherwise have under strict First Amendment law to an individual student. But what are your thoughts about that?
I would agree with you, Steve. I think we define what it means to be a community, and to be a recognized student organization on any Penn State campus should necessarily mean that that student organization respects the dignity of all students on campus, not just its members. And we can set the parameters. So, I think. Again, more speech is also appropriate in these circumstances. So from my perspective, it's insignificant. No, I should say it is not sufficient for the university response to merely be students have the right to say what they want to say under the First Amendment, and that be the end of it. When students engage in that kind of speech that demeans other students on campuses and injures other students' dignity, I think as leaders of the university, we have a moral imperative to put our speech out there that kind of behavior is not condoned by the administration, and that we need to send a counter message to the people whose dignity was injured, that they are respected, they are welcomed, and that this kind of behavior, while it may be protected by the First Amendment, is not sanctioned by the values of this institution.
Yeah, Steve, you want to?
I don't disagree legally with what Carla said. If I were advising a student organization who is outraged by the sorority's activity, the question is who should we focus on? And rather than protesting in Old Main demanding that President Barron take some official act, I would rather advise, and I think it would be better, if students started picketing the sorority house until the president, and naming the president of the sorority, until the president of the sorority acted in some way. I don't know how sororities work, you penalize people, but acting in some way so that the sorority would be accountable in some way. So I don't disagree legally with what Dean Pratt said, but sometimes things are harder, but you'll get a better result from doing it that way. it's easy for somebody to say, I'm hurt, I want Eric Barron to remedy it, and now I'm happy. And in some ways, I think it's a more mature and it's a harder thing to do, but that would be my response.
We have only 10 minutes, and I hope to give each panelist a minute or two at the end to say something. So I'd like to find out if there's a topic or a subject that people would like addressed. Yes, sir.
Yeah, I just wanted to further comment. I think one of the questions was how can the university step in and help in some of these instances of maybe hate speech that might be protected. I found myself as, for a lot of my time in Penn State, I've been ignorant of some of the viewpoints and experiences of people that identify with groups that I'm not a part of. And that hurts my ability to identify with them and quite frankly support them when they are there's hate speech spoken or that directly impacts them. And so learning from some of my friends who have gone through those experiences and seeing how different it is for them has been so beneficial to me and helps me as a private citizen dealing with other private citizens engage in preventing that and helping stop that. So I think that if there's anything that the university could do, it would be to promote more conversation and more opportunities for people that have been discriminated against to share their experiences, because there's the silent majority. That's the conversation that we're having, is that there are people that are silent and they don't know and they're not acting. So there's a very small group of people that are saying these very horrific things, and then the people that are being affected by them, there's no other response of people saying that's bad. So then they find that reflective of the larger group that the small hateful minority technically identifies with. So promoting more opportunities for conversation and more chances for stories to be shared will, I think, allow, and I think a good example of that is the World in Conversation courses, forums like this, giving, one of my friends is the president of the Writers Organized to Represent Diverse Stories. Hearing some of those stories and examples presented in an artistic form is so powerful and really helps spread that viewpoint that as many of us as empathetic people who are just ignorant of those issues to better identify and help prevent those situations outside of the legal realm, in my view.
Thank you. What a novel idea. Use education at an educational institution. But I should say, to give a shout out particularly to Dr. Barron and to Marcus on this, I mean, that is, as you noted, one of the purposes of this session. This isn't really a free speech session. This is part of a diversity and inclusion year-long program of which free speech is an issue. And so we're using this, but really, as I hope I said at the outset, to generate exactly the kind of conversation, and I think several of you have made very helpful comments that way. So we're going to run out of time. I want to give 1 minute to each person to say whatever they want here at the end, and then I'll close it at that point. So Bob, why don't we start with you?
Well, thanks very much. First of all, I think this is a great event, and I want to thank President Barron and the other folks who put this together. I think it's a great idea, and I hope it's not just the only session that the First Amendment is discussed. I think it's an ongoing discussion. It's a really important topic. I guess I would just close with a word of caution, because I think a lot of times in today's society, particularly as we listen to presidential candidates and the like, some of whom are very eager to close down speech, that there is a real purpose for having and allowing viewpoints from a variety of areas to come out. And it's not just going back to some of the old-time marketplace of ideas and other concepts that have been around for a long time, although I think they're very valid. There really is an enormous benefit from hearing from voices from divergent viewpoints. And a columnist by the name of Matt Hentoff wrote a book several years ago called Free Speech for Me, But Not for Thee. And the whole central theme of his book was that people are very eager to embrace the First Amendment when it reflects their own views, but they're very happy to stop the speech of others that they don't like. And I guess my word tonight would just be a word of caution. Let's not stop the speech of others that we don't like. Let's counter that speech, as Carla and other people have said tonight, and let's get the views out into the marketplace, because really those old concepts, like the marketplace of ideas, democratic self-governance, really do still work if they're worked appropriately. Thank you.
Okay, Victor, why don't you go next?
I completely agree with everything that Bob said, I would just add this little wrinkle. I do think, taking Dwayne's comment to heart, I do think it is important to be responsible with one's speech, right? At the law school, we talk about the fact that lawyers have as their sword and their shield words, and words do carry weight. So I do think while it is important to have a robust conversation, welcoming viewpoints from all perspectives, I think it is also important to think about how one uses one's words. And just as an example, I'm teaching criminal law this fall semester, and we talk about various crimes, including sexual assault. And so you can imagine that given the age of most of my students, this can be a very sensitive topic, especially when we talk about acquaintance rate. As a male professor, I'm particularly sensitive about that. And as someone who is, and you can ask Dwayne about this, who is normally a Socratic professor, that is, I call on people. When we talk about sexual assault, I say, I appreciate how this might be a sensitive subject to all of you. We have to talk about these things because these are important. But on the other hand, I will not go through the regular Socratic method that I usually employ. So I think that there's a balance here and the sensitivity and a responsibility that I'm glad Dwayne brought up.
Okay, Steve?
One thing we didn't have a chance to talk about, obviously it's a broad topic, is political correctness and what's the difference. Political correctness is a term originated by the Pennsylvanian James Wilson, a drafter and founder and first Justice of the Supreme Court, and it became popular in the 50s when aging leftists would accuse each other of moving out to suburbia and behaving in a way that was not consistent with their own behavior. Under this original term, Rush Limbaugh is completely politically correct because everything he says corresponds to his own politics. Political correctness is living your life based on your politics, not someone else's. And one of the things that we do need to have a serious conversation about, and we don't have time today, is how do you navigate those boundaries? How do you have a conversation about affirmative action where not every opponent of affirmative action is racist? How do you have a comment about Israel where not every critic of the Netanyahu government is anti-Semitic? And there needs to be an openness in this conversation, not just by people who are privileged white males, but also people who are in traditionally subordinated groups need to articulate those differences so that everyone can understand it, and so people whose politics are trying to be inclusive and sensitive can figure out how to conform their behavior to their own values and their own politics, given that I believe most of us really do share the values that President Barron articulated at the beginning of the day.
Okay, Carla?
I would just say that status matters in speech. And so one of the skits was the professor, the English professor who made a statement about, oh, I see you're coming to class on CP time, colored people's time. And I cringed because I said, oh, that's something I've actually said. But I get to say it as a person of color to my students who share my racial identity. It's kind of like if your mama's overweight, you could talk about that, but I can't talk about your mama, right? Same thing, right? So status matters, and if we're mindful of that, and we're mindful of our status when we speak and the status of the listener, I think we'll avoid some miscommunications that happen that may be received as harm intended when actually no harm was intended.
Okay, I'd like to close with two quick comments. One is, I think President Barron, he can obviously speak for himself and Marcus, but the conversations I've heard in the President's Council and elsewhere at the university are exactly what was suggested back there. Don't get hung up on the First Amendment. Don't use the First Amendment as a defense. Don't say we can't do this, we can't do this, we can't do this. Figure out what's right, and let's do it. So I do think that's an incredibly important point, and I think as we move forward as an institution, that's important to keep track of. At the same time, on the doctrine level, I'm going to make a prediction. I think most people in my job at other colleges and universities, most faculty, I dare say, at law schools, believe that the First Amendment is closer to the absolutist concept, and that the current demonstrations from Black Lives Matter to women's groups and others don't understand it and are out of sync. And my prediction is that the Supreme Court over the next 10 years is not going to overturn a bunch of cases, but is going to expand the notion of what can be protected by institutions without running afoul of free speech. I think interests of safety, interests of non-discrimination, interests of welcoming environments, interests of racial and other minorities will grab a greater share of the attention of the doctrine of the law as it develops, and we will see a development that reinforces our ability as an institution to do the right thing without violating the First Amendment. So unless President Barron or Marcus, anything further to say, I think we can bring this to a close. Thank you to the panel. Thank you to all of you.